Well, good afternoon, ladies. I am Michelle Easton, president of the Claire Booth Luce Policy Institute. Thank you all for coming today, and welcome to our June Conservative Women's Network. Special thank you to Bridget Wagner, who is co-host here. She is the new vice president of the Heritage Foundation, and Becky Dunlop, who used to be vice president, is now the Reagan Fellow. Congratulations. And we've had a wonderful partnership with the Heritage Foundation, putting these on almost every single month for 17 years. What great fun. I'm glad to introduce today's speaker, Hannah Smith, who will discuss how the courts have become a major battleground in our nation's policy debates, and she'll address some of the key issues playing out in the courts today. She'll also tell you a little about her own life, which is very, very interesting. Hannah Smith is the senior counsel at the Becket Fund. She joined the organization in 2007 following two clerkships at the U.S. Supreme Court for Justices Clarence Thomas and Samuel Alito Jr. Hannah was a member of the Becket legal team that secured victories in several U.S. Supreme Court religious liberty cases, and she contributed to many other Becket Supreme Court filings. She's been featured on numerous television and radio programs, as well as publications she's written for the Wall Street Journal, the Washington Post, and the Los Angeles Times. Hannah received her BA from Princeton University and graduated with honors from Brigham Young University Law School. Following law school, in between clerkships, she was an associate in private practice at firms Williams & Connolly and Sidley Austin in Washington, D.C., representing clients before state and federal courts and the U.S. Supreme Court in civil, criminal, and constitutional cases. Hannah served as a full-time volunteer missionary for the Church of Jesus Christ of the Latter-day Saints in France and in Switzerland. She currently serves as a member of the J. Reuben Clark Law Society International Board and as a member of the Deseret News Editorial Advisory Board. She writes mostly on religious liberty issues in the Deseret News. Hannah and her husband, John, have 4 children from 10 to 2 and a wonderful family. Please join me in welcoming Hannah Smith.
It's so nice to be with you all today. I love looking out over this room and seeing your beautiful faces and your optimism and the beautiful smiles that are here. So thank you so much for coming. And I hope to be able to have a good discussion with you all today about a lot of different issues. They asked me to speak about my experience in Washington as a lawyer, working on some of these interesting constitutional legal issues. And then my impressions of the Supreme Court from the perspective of a former clerk. And then we're going to have some time for Q&A at the end, so I'm happy to answer any questions you may have about work-life balance and any other issues that you're thinking about as you're beginning your careers and trying to make a course for your life. I also want to talk to you a little bit today about women in the defense of religious liberty. And I'm going to do that in the context of a couple of our cases, talking about how women were instrumental in raising their voice in defense of our Constitution and defense of our rights to religious freedom. So a quick disclaimer before I start, and that is that I'm here speaking on my own. I'm not representing the Becket Fund in its official capacity, so these are my views and not the views of my employer. So I want to start out a little bit about the Becket Fund for Religious Liberty, and Bridget Hassan over here is well familiar with the Becket Fund, as it was her father who founded the Becket Fund back in 1994. And so for the past 22 years, the Becket Fund has been in the business of defending religious liberty for people of all faiths. We like to say from A to Z, from Anglicans to Zoroastrians and everything in between, including Buddhists, Christians, Hindus, Jews, Muslims, Native Americans, Sikhs, and Zoroastrians. We are a nonprofit, nonpartisan, public interest law firm based right here in Washington, D.C., and we work in the courts of law around the country, in the court of public opinion, which is becoming increasingly more important, and also in academia around the country and around the world. So is religious freedom threatened today? You bet it is. Absolutely. We see it every time we open up the newspaper or read online. But I don't want to talk today about all of the negatives. I don't want to be gloom and doom here talking about how our First Amendment freedoms are being whittled away and how we're losing our religious liberty rights and how the next 10 years look gloomy. I'd like to talk about some stories of hope, some stories of victory, and inspire you with some of the reasons why we at Becket have cause to be optimistic, why we think that we're winning a lot of these battles, and we think that we can continue to do so over the next near term. So I hope these stories will show you how standing up for our Constitution and for religious liberty matters. It matters not only because it yields success in courts of law, but more importantly, it means triumph in the lives of everyday Americans. And I think that's what you'll see in the stories a couple of stories I'm going to share with you today. So in the last 5 years, I've worked on all 4 of our Supreme Court cases, and our legal team has had enormous success in achieving positive outcomes for our clients. And I want to talk about just 2 of those cases a little bit in depth today. 2 of them that I think you've probably heard of, the Hobby Lobby case and the Little Sisters of the Poor case at the Supreme Court. And I'm seeing some heads nod out there, so this is a good thing. First, let's start with Hobby Lobby. So 40 years ago, when Barbara Green and her husband David started their family craft store in their garage, making picture frames, they promised that they would run their business in a way that reflected their Christian religious beliefs. And 40 years later, they've stayed true to that promise. Although their craft stores, named Hobby Lobby, are now a national chain and a household name, Barbara and David still adhere to those core religious values that drove their business from the beginning. They still care for their employees by closing on Sundays and paying starting salaries that are twice the minimum wage. And the Greens are also pro-life. And because they're pro-life, they have excluded abortions from their generous employee health plans. So, when the Affordable Care Act rolled around and the HHS mandate was issued, and the federal government ordered them to cover these life-ending contraceptive drugs in violation of their deeply held religious beliefs, the Greens fought back. And, as you know now, they won. The Supreme Court protected Barbara's business from crushing fines and told the government that it had to find another way to accomplish its objectives without forcing Barbara to violate the religious principles that motivated the founding of her company. So Barbara is a wonderful woman, and during the course of the Hobby Lobby case, she really stepped forward and became the spokeswoman for this legal case. She got out in front of the microphones, she spoke to the media, she appeared in videos, she led the crowd of supporters on the Supreme Court Plaza the day of oral argument, and she recalled at one point during one of the videos that we recorded with her in it, she recalled the story of Esther, who was prepared for such a time as this. And I think that story really motivated her and really helped her find the courage to stand up and be the spokesperson for this cause. And she found her voice in the defense of religious liberty. And because of Barbara's courage, religious businesses now, not just Hobby Lobby, but religious businesses around the country are protected by the Religious Freedom Restoration Act from violating their religious beliefs and the HHS mandates crushing fines. So let's talk about the Little Sisters of the Poor. The Little Sisters are an international order of Roman Catholic nuns who spend their lives serving the elderly poor. The Little Sisters will sit by the bedside of their elderly patients, and they will hold their hand, and they will sing to them until they breathe their last breath. These women are doing God's work. And their Catholic faith infuses everything that they do, including the healthcare plans that they provide to their employees. In fact, their benefits provider is the Christian Brothers Trust. And that's a Catholic organization that provides the Little Sisters and more than 400 other Catholic organizations, charities, with healthcare plans that reflect their common faith. So again, we go back to the Affordable Care Act and the HHS mandate. And when the federal government ordered the Little Sisters to let their Catholic healthcare plan be used as a vehicle to deliver these contraceptives, these emergency contraceptives, in violation of their faith, the Little Sisters of the Poor fought back. And even though lawyers for the federal government said these nuns were fighting invisible dragons, I'm not joking, they actually said that in a legal brief, that the Little Sisters were fighting invisible dragons. The Little Sisters persevered, and just last month, the Supreme Court granted them a 3-part victory. So what happened last month for the Little Sisters? There was a unanimous per curiam opinion where the Supreme Court vacated all of the courts of appeals opinions that had gone against the religious liberties in the courts below. So that means they just erased them. The Supreme Court said they're gone with the stroke of a wand. And all of those bad opinions have been erased from precedent, which is a good thing not just for the Little Sisters, but it's also a good thing for future religious liberty cases that would have been stuck under those bad precedents. Second part of this great victory, the Supreme Court forbade the IRS from levying millions of dollars of fines against the Little Sisters. Now, to me, this is just incomprehensible how the federal government could threaten the Little Sisters of the Poor with $70 million of fines if they refuse to cover these services in their health plans. These are sisters who, I had their card the other day and I was looking at it, and one of the Little Sisters, the title under her name was Begging Sister. Okay, these are sisters who go around begging for money to support their ministry, to help the elderly poor. And the idea that the IRS would come in and levy $70 million of fines, which would effectively crush their ministry, is just appalling to me. So the Supreme Court said you cannot levy those fines against the Little Sisters, which was a huge victory for them, obviously. And then the third part of the victory was that they told the lower courts to provide the government an opportunity to arrive at an approach that would accommodate the Little Sisters' religious beliefs. So going forward, there will be an opportunity for the government to change its position and to accommodate the Little Sisters' religious beliefs. Again, like Barbara Greene in Hobby Lobby, the Little Sisters were the public face of this legal challenge, of the media campaign around this legal challenge for all of the religious ministries that were challenging this HHS mandate in court. So you'll remember it wasn't just the Little Sisters case that was before the court, but it was also a group of religious universities and colleges and other religious nonprofits. But the Little Sisters really emerged as the face of this campaign. And what a compelling face they were. The ultimate David and Goliath, right? A group of nuns standing up against the federal government that has ordered them to reject their Catholic teaching. Mother Lorraine and Sister Constance responded to a flood of media requests for interviews and for op-eds. And the day of oral argument, nuns in habits filled the Supreme Court Plaza with signs chanting, "Let them serve, let them serve." And my husband and my 4 children were there that day on the Supreme Court Plaza while I was inside the Supreme Court during oral argument. And they held up signs and cheered. And I thought to myself, isn't this ironic that even small children understand that the government should not be bullying nuns? So apart from the legal presentation of the issues before the court, both Hobby Lobby and the Little Sisters involved significant coalition building efforts to win the court of public opinion. And I want to talk a little bit about those coalition building efforts now, because oftentimes we think about just the legal aspect of the case, but there was a significant amount of not just media efforts, but also coalition building and public efforts to convince in the court of public opinion what we were trying to argue in court. So first, this involved amassing like-minded public interest organizations that were willing to file friend of the court briefs in support of our clients. And second, it involved organizing public rallies like the one that was held the day of oral argument at the Supreme Court. So many organizations like Claire Booth Luce and others that are effective at galvanizing support of conservative, independent women came to defend Barbara Greene and the Little Sisters. Organizations like Concerned Women for America, Susan B. Anthony List, Women Speak for Themselves, Independent Women's Forum, a lot of these other organizations really rallied around Barbara Greene and the Little Sisters to support them, not just through friend of the court briefs, but also through these rallies and through public messaging about the case. And I think it's largely thanks to these hugely successful coalition-building efforts that we were in large measure able to overcome the media's war on women theme. If you remember how much of the media focused on these religious groups were really waging a war against women and attempted to paint our side as allowing employers to come in and take away women's birth control, which was just nonsense. It was never the position of any of our clients that they would not allow their employees to access this contraceptive. It was always their position that they just did not want to be a part of it because of their religious beliefs. So it was an honor for me to work with these inspiring women to defend their right to religious liberty at the Supreme Court. And I want to shift gears a little bit now because they asked me to speak about my experience at the court from the perspective of a former clerk and in the context of what we're seeing now with the nomination and confirmation issues surrounding the replacement of Justice Scalia. So as we've seen, the Supreme Court is now front and center in our nation's public consciousness. Justice Scalia's death in the middle of the term was a tragedy, not just for the Scalia family, for all of us who have clerked and worked at the court, but for our nation and for the future of the court. And I think all of you have probably seen in the news, if you've been reading some reporting on the court's recent decisions, the court has had to grapple with the possibility of tie votes in several of its very high-profile cases. So a 4-4 equally divided vote means that the court affirms the lower court's opinion without creating any precedent. So it's as if the Supreme Court never got involved in the case at all, and the lower court opinion stands. So we've seen several 4-4 ties in some cases this term, and we may very well see some more before the court adjourns at the end of this next week and goes on its summer break. But the more important question in my mind is who is going to fill this ninth seat? And we're seeing now, and we'll continue to see in the months to come, that the current Supreme Court vacancy and the possibility of several more vacancies in the future is going to be a critical issue in the coming months. My husband John and I were actually very involved in the confirmation battle to get our former boss, Justice Alito, onto the High Court. So we've seen up close how this process works during the confirmation battle, and I thought you might be interested in just hearing a little bit about that experience because we'll be seeing these issues play out over the next couple of months. So when Justice Alito was nominated on October 31st, 2005, we organized his former clerks into an army of truth tellers. We were the truth squad. And we were committed to speaking the truth about our former boss, about his judicial record, and about his temperament, and why he was supremely qualified to fill this vacancy on the court at the time. He had been nominated to replace Justice Sandra Day O'Connor. So over the 3 months between his nomination and his confirmation, we, as his former clerks, met with senators and with their staffers, both in home states around the country and here on Capitol Hill. In states around the country, when we would meet with the senators and their staffers, we would also meet with local media and with pundits, with interest groups and concerned citizens. We drafted case law excerpts highlighting his significant contributions to every area of the law. We compiled statistics about his record. We fashioned talking points to counter the ugly lies that were being spread about him, this man that we all knew and deeply respected. And several of his former clerks actually participated in the hearings before the Senate Judiciary Committee, providing testimony about Justice Alito. And we drafted a letter of support that we submitted to the Senate Judiciary Committee. Many of us became surrogates in the media. I actually appeared on a C-SPAN segment talking about the judge and did several TV spots for him. We gave interviews to print journalists. We wrote op-eds supporting him in newspapers around the country. And we participated in press conferences. We had one at the National Press Club. We also were invited by President Bush towards the end of the process to come meet with him in the Oval Office, where he thanked all of the former clerks for the great work that we had done in supporting his nominee, and then invited us to join him in a press conference held at the old Executive Office building across from the White House, where he stood flanked by former Alito clerks and urged the Senate to vote to confirm Judge Alito. So it was a really wonderful experience to stand there with these former clerks who were Republicans, Democrats, and independents. Judge Alito had clerks that were from across the political spectrum, and all of us stand there in united support of him and his nomination to the Supreme Court. So these 3 intense months between October 31st and January 31st, we really helped reshape the image of someone who the media tried to paint as unacceptable into the accurate image of someone who was intelligent, fair, and supremely qualified for the job. And then, of course, it was just with great joy that the former clerks were able to attend the White House swearing in, where Justice Alito became the next justice of the Supreme Court. So I give you that background just to kind of highlight how these confirmation battles work, what goes on behind the scenes in Washington, why we need very committed people, not just former clerks, but there were cadres of important people in the Department of Justice, in the White House counsel's office, in public interest groups around Washington, including the Federalist Society, with whom I'd had a lot of contact both in law school and then during this process, working to support this nomination. So it was really a large effort that included a lot of different people speaking up for the Constitution and for a nominee who was very well qualified to serve in that capacity. So I'll just sort of end here by saying I hope for the sake of our country and for our children's future that the next justice will be someone who will protect and defend the Constitution and religious liberty for people of all faiths. I just want to end with a few thoughts on what all of you can do, wherever you are currently in your life, wherever you see yourself going in the future, to protect religious liberty, because it's really important for me, for us at the Becket Fund, that there are people like you out there who become educated on the issues, who want to stand up for religious liberty wherever you find yourself in your career. So the first thing that I would encourage you to do is just become educated. You need to really learn what the issues are. And I would encourage you to go to our website, becketfund.org, Becket with 1 T, not 2. Go to our website. There are a host of resources there that will help you really become knowledgeable on what the issues are in defending religious liberty. If you want to know more about what does the Free Exercise Clause really protect, what is RFRA and how does it interact with the First Amendment, and what are all these state RFRA battles that I'm hearing about in the news and why are they so important, go to our website and learn more about those. You'll also learn about how we defend people of all different faiths and why that's so important, why it's so important to have a principled approach to religious liberty, not just for Christians, but for everyone. And then I encourage you also to watch for opportunities where you can be a voice of calm in heated rhetoric. I think you need to take the opportunity to get to know your neighbors, get to know the people of other faiths that you live with, that you work with, that you may be friends with. Find ways to serve with them. In my faith community, we have been very involved in building bridges with people of other faiths through service opportunities. And I found it immensely rewarding to be involved in the public affairs work of my church, such that I'm able to be friends with the Methodist pastor down the street and the Church of the Brethren and the Muslim mosque that's near our neighborhood, and to be working side by side with them in service opportunities to provide relief for refugees, for example. We had a coat and blanket drive recently in our church congregation. These kinds of opportunities are immensely rewarding for everyone involved. And the reason why they're so important is because when you build relationships through service, then when the opportunity arrives to stand arm in arm to defend each other over issues related to religious liberty, you already have trusting relationships that you have built with other people of other faiths, that then you can rely on those trusting relationships to stand together in the defense of these important constitutional principles and important issues of religious liberty. So I'll just end there, and I will open the floor for questions, but I thank you very much for coming today, and God bless you.
Excellent. Thank you. I think we have some microphones here, and I'll let you call on people,
Sure.
okay? If you would state your name and where you're working or your affiliation. And wait for the microphone, because this is taped, so we want to hear your questions. Don't be shy.
Hi, my name is Danielle, and I'm an intern at the Claire Booth Luce Policy Institute. And I was wondering, at your time with the fund, has Obamacare been the legislation that has really put the most threat to religious liberty? Is that the kind of legislation that you've had to work a lot with countering, or has there been other legislation that has had a significant threat to religious liberty in your time working in this kind of stuff?
That's a great question. Thank you. So I've been at the Becket Fund for, well, this is my 9th year, and we started the litigation against the HHS mandate back in the fall of 2011. So we've actually been litigating these cases for almost 5 years. So almost half the time that I've been at the Becket Fund, we have been litigating these cases. And it's been an interesting experience to see how this has played out, because what's really interesting about this is that most of the work that has been done by the government on this is through regulations, through administrative agency regulations, right? Congress passed the Affordable Care Act, but they delegated to the Department of Health and Human Services to promulgate the regulations that would actually create the HHS mandate. And so those regulations over this, 4 or 5 years we've been litigating have been changing as the department has changed the regulation to provide its so-called accommodation, to change things here and there. So the goalposts have kind of been moving, which is why the litigation has been going on for so long. But we have dedicated a significant amount of resources to fighting the HHS mandate for the last 4 or 5 years, in large measure because we think it's such a gross overreach of federal government power. We think that the promulgation of these regulations by faceless bureaucrats who have no accountability and who seek to crush, these deeply held religious beliefs of our clients is just wrong, and it needs to be countered. And so we have committed a significant amount of resources to fighting that regulation. But we have also, at the same time, maintained a full docket of other cases. So we've been fighting, Mr. Newdow's attempt to crush under God and the Pledge of Allegiance as he goes around the country and files lawsuits all over the place. We've been maintaining that litigation throughout this time. We've also been maintaining an active docket of cases fighting Blaine amendments, which are state constitutional provisions that have roots in anti-Catholic bigotry that are preventing state governments from giving state funds to churches simply because they're religious, when the federal interpretation of the Establishment Clause would allow them to receive those funds. So there's a lot of other cases that we've also been litigating at the same time, but the HHS mandate cases have really taken a significant amount of resources, but also have received the most media attention, which is probably why you've heard most about them. Sure. Good question. Yeah.
Hi, I'm Clarissa Sutter, and I'm an intern here at Heritage this summer. I just wanted to ask you if you could speak a little bit about the balance between your professional and family life that you spoke about at the beginning, and then just what really inspired you to work in the field defending religious liberty.
So I'll take the last question first and then go back to the first one. So I became interested in religious liberty actually when I served as a missionary overseas in France. And it was after my graduation from college, and I served as a volunteer missionary. And I was in France at a time when actually the French government had created a governmental commission to monitor certain small religious groups that it found to be different from traditional faiths. And, some of those groups, my church was actually not on the list that it had compiled, but many of those churches that were on the French government's list were, American churches that had come over to France to proselyte and to establish themselves. And the French government just started to make life really difficult for a lot of these minority religious groups in France. And to me, that seemed really interesting as a young person. Why would the French government want to suppress the free and open marketplace of ideas when it comes to religious beliefs? And so I came back to law school and actually went to Brigham Young University Law School, where there was a law professor who recruited me and my husband to come there to work with him on religious liberty issues. And Professor Cole Durham is an expert in international religious freedom, and he goes around the world helping people in government draft constitutional provisions that are more open and free to religious liberty. And so we worked with him for 3 years in law school, and then after I graduated from law school, came back to the East Coast to clerk for Judge Alito. And of course, Judge Alito has a long history of really significant opinions on religious freedom that he has drafted as a jurist. And then after that, I came to Washington, D.C. and worked at a couple of law firms where they had some practice area focused on religious liberty. And so I was able to do, in addition to regular legal practice, some pro bono work on behalf of religious organizations, which was really interesting to me. And then after my clerkships on the court, I ended up going to the Becket Fund because I was really interested in working with them and promoting their mission and their view of religious liberty. So that's sort of how I became interested in religious liberty and how it tied through the rest of the phases of my life and how I ended up where I am now. And as far as, work-life balance, it's such an important issue and one that I know that so many of you in this room are probably thinking about, one that I certainly thought a lot about and still do. I think it's one that you have to think about in light of the phase of life that you're in. I think for women, there are different chapters of your life, and certain chapters require much more focus and intensity on certain issues than on others. I am a big proponent of the idea that I think women in this day and age have so many more opportunities and so many advantages and so many capabilities to be able to have it all that we need to work hard to find those opportunities where we can balance our family commitments with our work commitments. I love my children. They are the light of my life, and I have 4 beautiful kids, and I cherish the time that I have to spend with them when they're young. It's really important to me. And so finding an opportunity to work like I have at the Becket Fund, where I can do meaningful work and also be very committed to my family, is something that was really important to me. So I urge you to just be very prayerful and thoughtful about it, and I think that there will be opportunities and avenues that will open up before you that you didn't even plan on. And that was certainly the case for me at the Becket Fund. I did not seek out the Becket Fund. Seamus Hassan called me and recruited me to come there, and it was not something that was even on my radar screen, but it was an answer to my prayer.
Thank you so much for being here today. Can you hear me? All right. I just wanted to ask, piggybacking off of that previous question, in response to all the hateful rhetoric going around about Sikhs, Islamic countries, South Asian religions in general, what would you say that all of us in this room can do to step forward in bridging religions rather than dividing them and segregating?
That's an excellent question, and I think it sort of ties back to what I was saying at the end of my comments, which is that I think just building bridges with relationship building is so important. Working with your neighbors who are in a Muslim community in your area to provide relief for refugees, for example. I mean, what a wonderful opportunity to build those relationships and build those networks of trust. I think when people get to know each other on a personal level, so many of the sort of prejudices fall away. And so I would just say, particularly now, when there's so much of that rhetoric going on, I think that that's an important thing to do. Certainly at the Becket Fund, we have defended the rights of our Muslim friends and their ability to practice their faith, their sincere faith, in a peaceful way. And that's something that the Becket Fund will continue to do because we believe in the right of every American to practice their faith. Yeah.
Hi, I'm Sofia, and I'm an intern at Heritage this summer, and I'm actually also a student at Princeton.
Great, go Tigers.
I just wanted to ask if you had any advice for those of us who want to work in religious freedom issues kind of more professionally. And also kind of unrelated, but it seems like in the court of public opinion, we're losing the battle in terms of cases of weddings now because it's being framed as an issue of discrimination. And I guess in terms of addressing the court of public opinion, how do you think we can address that in love but still protect these rights and counter the claim that this is somehow, the same as Southern segregation? Thank you.
Sure, good question. So for those of you interested in religious liberty, I would just encourage you to identify the various organizations like Becket Fund that do this kind of work and do it well. There are some other organizations out there, not as good as Becket, but great organizations nonetheless, who do great work, and we are friends with and colleagues with, and we love to work together with on cases. So I say that in jest. They're great places. Get to know those organizations and get to know what opportunities may be available for you there as well. Becket is a pretty small shop, so we only have about, 10, 12 lawyers on staff. We're pretty small, lean machine, but I think there are a lot of opportunities for you to get involved in religious liberty work, both from a legal perspective, but also from sort of a policy perspective. And a lot of different organizations, like Heritage, for example, has a wonderful religious freedom shop here. So, and then on your second question, I think, obviously, I think these kinds of cases are going to be coming to the forefront more and more now, post-Obergefell. And I think there's a lot of really good scholarship that has been written about why these kinds of cases should be resolved in a way that respects the rights of both sides. The Becket Fund actually hosted a conference many years ago now, and we produced a book out of that conference, and it's called Same-Sex Marriage and Religious Liberty, Emerging Conflicts. And Professor Doug Laycock of UVA Law School and Robin Fretwell Wilson and Anthony Piccarello were the editors of that book. And each chapter is a chapter that has been written by a First Amendment scholar from around the country, talking about the kinds of conflicts that would emerge between same-sex marriage and religious liberty. So I would encourage all of you to go on Amazon and get a copy of that book if you have any interest at all in this area. There is a great discussion in that book about the specificities of how these kinds of conflicts should play out so that each side can live according to their beliefs and be respected and not discriminated against. Yes.
Hi, I'm Anna Marie Ranzi, and I'm a student at American University, but formerly I interned for Congressman Chris Smith of the Pro-Life Caucus.
Mm-hmm.
So my question is about the future of the pro-life movement. Do you see it moving in the direction of a more solely religious freedom issue, or do you see it more becoming secular and more of a human life issue as movement progresses?
So at Becket Fund, we don't actually have sort of a subsection of pro-life litigation. The Alliance Defending Freedom has sort of their family section and their religious freedom section and their pro-life section. We at the Becket Fund focus solely on religious liberty, so we don't actually have positions to answer your question on that specifically from a Becket Fund perspective. But certainly, I think we've learned a lot of good lessons from the pro-life movement post-Roe v. Wade that I think are really important for the post-Obergefell same-sex marriage context. And that is this, that even though the court granted a right to abortion in Roe v. Wade, following Roe v. Wade, we had significant protections put in place through legislative amendments like Weldon and Hyde and all of these other amendments that protect the rights of religious people to not participate in abortion or activities related to abortion. So I think that's a really good model that actually shows that even when the Supreme Court grants the right to something like abortion or same-sex marriage, there can be, following those decisions, protections legislated that will allow religious people to maintain their liberty even in spite of those constitutional rights. Yeah.
Hi, I'm Anna Paff. I'm with the American Principles Project. And I had a question, thinking specifically along the lines of the recent editorial by the New York Times editorial board denouncing the decision of a community in New York to allow Jewish women, Orthodox Jewish women, to have specific pool hours that were women only so they could conserve modesty. Can you explain a little bit about the balance between just America having a tradition of accommodating religious differences and just as a cultural, a unique cultural aspect of America, and then the legal ramifications of actually using public hours and funds to accommodate for religious groups in that manner?
Sure. So I think that's a really interesting question. And I think it really goes back to sort of the fundamental principles upon which our country was founded, right? Because our country was founded upon the principle of religious pluralism, that this country was going to be different from England and from Europe, where we allowed people of different faiths, of different congregations to come to live together peaceably and to allow for differences in religious culture and religious faith and religious tradition in a way that respects all of those different differences. And so I think that there has to be a way that we can accommodate all of these different religious minorities who will have differing claims on our cultural expectations, right? And so we see that, for example, in the case where we defended goat sacrifice in Texas, right? We defended the rights of a Santeria priest to sacrifice small animals in his home as part of his religious tradition. And now there are a lot of people in his neighborhood and in the surrounding community who thought, well, that's different. That's just not really traditional Judeo-Christian practice, right? That's just a different religious tradition that we're not quite comfortable with in our backyard. But we defended that principle because of the broader principle of the right to worship in one's own home. Can the government come into your home and tell you what you can and cannot do based on your religious beliefs? And we were successful ultimately in the Fifth Circuit in protecting that man's right under the Texas RFRA, which was a really important decision out of the Fifth Circuit. So just to give you that sort of an example of where minority religious views that are sometimes not well understood or not well accepted can be the cause of tension, like the example that you raised in New York of the Orthodox Jewish swimming hours. And I think that, ultimately there has to be a way that we can provide for accommodations to religious minorities that protect their ability to practice their faith without having the system just completely fall apart, right? Because a lot of times what bureaucrats say is, well, if I give an exception to them, then I have to give an exception to everyone, therefore I'm not going to give an exception to anyone. And that simply can't be the way that we resolve these issues, right? We have to find a practical way that we can accommodate these kinds of religious differences so that everyone can live peaceably and together in the same community. Any other questions?
I wonder if I can ask.
Yes.
I mean, you mentioned RFRA and the Texas RFRA law. How do you see this kind of next stage playing out with the state RFRA laws, the First Amendment Defense Act that's been introduced, I guess, in the Congress? What do you think ultimately will need to happen for us to truly protect religious liberty?
So it's been somewhat frustrating for us to see the public misconception about these state RFRA laws that has developed over the last couple of years. Just to give you a little bit of background about RFRA and why this has become an issue. So prior to 1990, the Supreme Court had a legal test that it employed when evaluating whether there should be exemptions given for religious exercise where the government had substantially burdened that religious exercise. So there was a balancing test, and it was from Sherbert and Yoder. And it said if there's a substantial burden on religious exercise, then the burden shifts to the government to show that it has a compelling interest and that it's forwarding that compelling interest by the least restrictive means. And so that balancing test was quite favorable to religious litigants. But in 1990, Justice Scalia, actually, in a case called Employment Division v. Smith, held that if a law is neutral and it's generally applicable, it applies to everyone, then we're not going to employ the same balancing test, the stricter standard to review these claims for exemptions. And that was a real jolt in the legal world. And following Employment Division v. Smith in 1990, Congress actually passed the Religious Freedom Restoration Act several years later. And it was a bipartisan effort by Senator Hatch and Senator Kennedy, who came together across the aisle to pass this legislation. There was only 3 votes against it in the Senate, so it passed unanimously in the House and was 97-3 in the Senate. So it was an extremely bipartisan effort to pass the Religious Freedom Restoration Act initially. The federal RFRA was struck down as it applied to the states in a later case called City of Bernie v. Flores, and that decision meant that the federal RFRA only applied to the federal government but didn't apply to the states. And so in light of Bernie, the states actually kicked into gear and started passing their own state RFRAs. So there were many states in the late 90s, sort of 97 to early 2000, that passed state RFRAs that largely mirrored the federal RFRA. And what federal RFRA did was reinstate this compelling governmental interest standard in evaluating these claims. So it reinstated this more favorable legal standard. And so states started doing this around the country and passing state RFRAs. In the end, there's something like 21 state RFRAs that are now on the books. And when those initial states passed these RFRAs in 1997 to early 2000, there was no controversy at all because there was such a spirit of bipartisanship at that time, and both Republicans and Democrats had seen how valuable this federal RFRA had been, and so it was not an issue. There was just no concern. And it's only been really in the last 3 or 4 years as states have either tried to pass a new RFRA or tried to change something about their existing RFRA, either expand it or change it in some way, that there has been increased opposition to those new RFRAs or changing of state RFRAs. And largely that opposition, I think, has come from a misunderstanding about what RFRA does. And we actually have a website up on our site called RFRA Central, and we've tried to debunk some of these myths about RFRA and what RFRA does and does not do. And we have a fact versus fiction tab in there with some great graphics about what RFRA does not do. It's not used as a sword to discriminate against people of LGBT people. It's not used as a sword to discriminate against others. It's used as a shield to protect religious minorities. And we have another tab on the RFRA central page that highlights the stories of RFRA cases from around the country. And I love this page because it shows how many different religious minorities have been protected by RFRAs around the country. Sikhs who wanted to serve their country faithfully in the military were protected by RFRA to be able to wear articles of faith in the military, despite military grooming standards. Native Americans who recently were able to get back sacred eagle feathers that had been confiscated by the federal government that raided their powwow to take away eagle feathers that they said were held in violation of a federal statute. So Native Americans whose religious practices had been protected by RFRA. A World War II vet down in Florida who was feeding the homeless and was cited multiple times by the government for violating certain ordinances, and he was protected by RFRA. A variety of different Orthodox communities, Orthodox Jewish communities that were protected by RFRA. So a variety of different faiths who have been protected by these RFRAs around the country. And I think that just trying to dispel some of those misconceptions about what RFRA does and does not do is extremely important, because right now, unfortunately, I think people, for probably less than pure motives, are buying into this notion that RFRA is a law that is used to discriminate rather than a law that's used to protect against discrimination against religious minorities.
Anybody else? Well, what an excellent presentation. Thank you so much.
I appreciate being
We
here.
have a couple little gifts for you.
Oh, thank you.
We have our limited edition Claire Booth Luce Policy Institute coffee mug.
Oh, thank you.
With
my
her-
favorite color, purple.
Funny little observation, Mrs. Luce's.
Oh, good.
What is it? They all know.
No good deed goes unpunished.
There you go. Every mother of four needs a purple tote bag, huh?
Excellent. Thank you.
And before Bridget speaks, I want to say today is special for a number of reasons, certainly having you speak, but also I want to invite you all when we have our lunch to have a piece of Bridget's birthday cake. Happy birthday!
I was trying to fly under the radar, obviously, but it didn't work. Thank you.
Thank you so much.
And just a little token from Heritage Foundation as well.
Oh, thank you.
We want to invite you all to join us. We're going to be in the Kleintobe lobby, just out the corner and to the right, a little different location for us. And we hope you can stay and continue the conversation with Hannah. So join me again in thanking her for speaking to us.